Good morning, good afternoon, good evening to everybody who's joined us today. Thank you for being with us in this webinar, which is a collaboration between 39 Essex Chambers and the Malaysian Middle Temple alumni. My name is Swee and I'll be MC today. I am an international arbitrator member of 39 Essex Chambers, and I am based in the Kuala Lumpur office. I act in third-party neutral roles, but today I will be that third-party neutral and be the timekeeper. We will be taking a canter through or a zoom through some 7 cases and 1 piece of legislation, all of which are topical and all of which are relevant to our everyday lives as lawyers and in the things that we're doing, especially in arbitration. We will not be having long speeches about each speaker's profiles. Please access their profiles from the names on our website in the invitation, as well as from follow-up emails that will be sent to you, which will also include full case citations of each of the cases that are being covered. So we've entitled this Interesting Cases from a Peculiar Year, the peculiar year being the year of COVID. So without further ado, may I ask Richard Wilmot-Smith, Past Master Treasurer, and Tan Sri Cecil Abraham, Bencher, to say a few words of welcome. Gentlemen.
Thank you, Swee, very much. Can you all hear me? Swee, can you hear?
Yes, yes, we can.
Brilliant. Thank you all very much for coming to this. This is a marvelous occasion, which for me linked 2 institutions. Of course, I was head of chambers for 8 years between 2003 and 2011. And I was treasurer of Middle Temple in 2018. And to have them come together like this is a real treat. I'd like to welcome all Middle Templars. Just one slight correction. None of you are alumni, you're all members, and you must come and see the inn whenever you are in London. It's a wonderful place, and I hope you'll enjoy the welcome that we can give you. Middle Temple has always been committed to education. Education is what it's all about, apart from the community that it lives. And this is this great event is part of that I see both 39 Essex and Middle Temple contributing to. But now I'm going to pass over to Master Cecil Abraham.
Thank you. Master Richard Wilmot-Smith, QC, members of 39 Essex Chambers, and to all the participants from all over the globe, greetings from Malaysia, and in particular from the Malaysian Middle Temple alumni. Firstly, I must say that the last time I met Master Richard Wilmot-Smith was when I sat, I think, opposite him at the high table. And I invited him to come to Malaysia when the Amity visit was supposed to take place, but unfortunately, COVID has prevented that. However, I would like to thank 39 Essex Chambers for hosting this webinar on behalf of all of us in Malaysia. We in Malaysia at the alumni have requested our younger members to participate in today's webinar because we are very proud of them and we want to introduce them to the world and give them an opportunity to speak this afternoon in Malaysia and this morning in the UK and elsewhere. And also, we're very fortunate that we will be having a number of silks and seniors from 39 to speak. Now, the cases which the Malaysian speakers would be covering are topical in the Malaysian context. They may not be in the English context, but it will still be interesting, I hope. And we in Malaysia look forward to further collaboration between Middle Templars all over the globe. And we hope that this will be one of many collaborative events which we hope we at TMTA will hold. And we are very keen in fostering fellowship among Middle Templars around the globe. With that, thank you, Swee.
Thank you very much, Richard, and thank you very much, Cecil. So without further ado, I think we shall launch into case number 1, and we will be leading, who will be leading the charge is David Brynmor Thomas QC of 39 Essex Chambers, based in our London office, who will be speaking about Anchor and Chubb. David, over to you.
Swee, thank you very much, ladies and gentlemen. Good morning, good afternoon, good evening. It's a real pleasure to speak on this webinar because actually, rather like Master Wilmot-Smith, 39 and Middle Temple are very, very dear to me. I'm a member of 39. I managed to have the then Master Treasurer, Richard Wilmot-Smith, attend my wedding when I got married at Middle Temple. So it means that much to me. And educationally, Middle Temple, I'm involved with mooting, advocacy training, and other matters that I think are very important. So I'm very pleased that we're able to do this. I want to talk about the case Anchor and Chubb, notable because it is one of the 2 English Supreme Court cases that we're dealing with this morning. Chubb was, or a Chubb subsidiary, is a party to each of those cases. I'm going to talk about Anchor and Chubb. Richard Wilmot-Smith will talk about Halliburton and Chubb. In my view, I would say this, Anchor and Chubb is the less notorious case, but in fact, in some ways is more interesting in terms of what it contributes to international arbitration, learning and doctrine than Halliburton, which I think had issues on its particular facts. Anchor and Chubb deals with the interrelationship that we all come across as international arbitration practitioners. And that is the interrelationship between the law applicable to the contract, the law of the seat, and the law applicable to the arbitration agreement. And in the last 10 to 15 years of my practice, I think the law applicable to the arbitration agreement has become more prominent in its importance. In Anchor and Chubb, there was a power station in Russia that had been constructed by a Turkish entity. The construction contract had an arbitration clause in it, but interestingly, because it was many hundreds of pages of contract, no governing law provision in it. There was a fire at the power station, and Chubb, as the insurer, settled claims by the owner and then brought subrogated claims against Anchor as the contractor. There was litigation in Russia. The arbitration clause provided for arbitration in London, and so Anchor sought an anti-suit injunction in London against the proceedings in Russia. And as part of that anti-suit application, the question of the law applicable to the underlying contract and the law applicable to the arbitration agreement had to be considered by the courts. And that's why this issue ended up before the Supreme Court. The choice of law applicable to the arbitration agreement splits, or the debate has split along 2 lines. The law applicable to the underlying contract or the law of the seat. And you will be aware that a number of jurisdictions take the law of the seat and say that the law of the seat is the law applicable to the arbitration agreement. Well, that's not where the Supreme Court ended up. Without going into the judgment in more detail than 5 minutes would stand, and it's a judgment of 115 pages, well worth reading. The conclusions of the majority are at page 58, paragraph 170 of the judgment. And they go through, if you like, in order, the circumstances that we as practitioners may encounter. First of all, where a contract contains an agreement to resolve disputes arising by arbitration clause, the law applicable to the arbitration agreement can be different to the law applicable to the other parts of the contract. It affirms the idea that the idea of dépassage may apply to arbitration agreements. When that happens under English law, ordinary common law rules apply to decide the law applicable to the arbitration agreement, not the Rome Convention on the choice of law in contracts. According to those rules, the common law rules, the law applicable will be either the law chosen by the parties to govern the arbitration agreement, or in the absence of such a choice, the system of law with which the arbitration agreement is most closely connected. Whether the parties have agreed on a choice of law depends on their express provisions. In short, the Supreme Court decided as follows: where the law isn't specified that applies to the arbitration agreement, but have chosen a law applicable to the underlying contract, then the law applicable to the contract will apply to the arbitration agreement. The choice of a different country as the seat of the arbitration is not without more sufficient to negate that. If, however, the choice of law would invalidate the arbitration agreement, whereas the choice of seat would validate the arbitration agreement, then you may be driven to the law of the seat. Where there is no express choice of law in relation to the underlying agreement, then you may be taken to the law of the seat as being the closest connection. But that isn't in itself necessarily determinative even then. The minority dissented very briefly, simply saying that the law applicable to the underlying contract should be the law applicable to the arbitration agreement, and that would even be the case if you were having to use other choice of law provisions. I think I've used my 5 minutes. I will stop at that point, other than with one piece of learning, which is this: it is always good practice in drafting an arbitration clause to specify the seat. It's always good drafting a contract to specify the applicable law. And I think in the light of Enker and Chubb, it is probably now good practice when drafting an arbitration agreement to specify the law applicable to the arbitration agreement. Swee, thank you.
Thank you, David. Having used up your time, we move on now to the next case. And for that, we'll have Stephen Lim, my colleague who's at 39 Essex Chambers, Singapore office. Stephen sits as an arbitrator. And Stephen's going to be telling us about the Singapore case of Bna against Bnb. Over to you, Stephen. Thank you.
Thank you very much, Swee. A real pleasure to be here this afternoon, Singapore time, morning in Europe, and evening perhaps for someone else who's with us today. I'm talking about Bna and Bnb. Those familiar with arbitration cases in Singapore will know that to protect confidentiality, all court decisions are anonymized, which is why we end up with a whole string of letters for most of our arbitration cases. Bna and Bnb is the decision of the Court of Appeal in Singapore. It was decided before Enker, well, at least before the Court of Appeal decision in Enker and Chubb and the Supreme Court decision in Enker and Chubb. It also deals with the question of the proper law of the arbitration agreement. I'll begin by walking through the facts and background of the case, because that's quite interesting in itself. And then I will end with some comments about how the court dealt with the validation principle, which is a principle that comes into play for the determining the proper law of the arbitration agreement, and contrast that with how the Supreme Court dealt with it in Enker and Chubb. But first, the background to the case. So the case concerned a tripartite arbitration in a takeout agreement for industrial gas. The parties were, one, a PRC entity, that was Bna, and then as respondents, there were two parties, BNB, which was a South Korean entity, and BNC, which was another PRC entity. BNB was the original seller in the takeout agreement, and Bna was the buyer. and BNC was a related company to BNB and subsequently took over BNB's obligations as seller by Novation. BNB, however, remained jointly and severally liable for BNC's failure to perform its obligations. PRC law is the governing law of the contract and therefore of the substance of the dispute. So the case really turned on the arbitration agreement in this case, and particular wording in the arbitration agreement, which was that the arbitration would be administered by the SIC under the SIC rules with arbitration in Shanghai. And the real problem with the case was, how do you interpret arbitration in Shanghai? What did that mean? The background to this as well is that under PRC law, two PRC parties, and in that case, this is BNA and BNC, could not agree to arbitrate disputes outside of the PRC. And it was also thought, or at least there was a serious question as to whether a foreign institution, that is the SIC, can administer arbitration in the PRC. So obviously the jurisdiction issue first came before the tribunal, which tried to save this arbitration provision, because if they felt, the tribunal felt that if they found that the arbitration agreement provided for arbitration by the SIC seated in Shanghai, then the arbitration agreement would not be valid, because there was a question as to whether the SIC can actually administer the arbitration in the PRC. So the tribunal, the majority of the tribunal, then applied the validation principle. And using that validation principle, found that Singapore law is the proper law of the arbitration agreement, therefore validating the arbitration agreement. That was appealed. That decision on jurisdiction was appealed to the High Court in Singapore. The High Court in Singapore applied what was the three-stage test in Sul America, which is ultimately the position which was adopted by the Supreme Court in Anchor and Chubb. So in that sense, BNA and BNB is consistent with Anchor and Chubb. And the court upheld the majority decision. The court found that Singapore was the seat of the arbitration, but in a rather circuitous and in my view, a rather tortured route. The court had to find that Singapore was a seat because the parties had expressly incorporated the SIC rules, the 5th edition, which is the old edition superseded by the 6th edition. And under those rules, there was a default of Singapore as the seat in the absence of the parties' agreement. And that's gone away. That's not in the 6th edition anymore. And therefore, because the arbitration agreement referred to Singapore as the default seat and also to arbitration in Shanghai, what the court said was that arbitration in Shanghai should be read as designating Shanghai as the venue and not the seat. I think this is where the reasoning got a little bit stretched to try and save this arbitration agreement. And then because Singapore was a seat, Singapore law displaced PRC law as a proper law of the arbitration agreement, applying the Sul America test and applying what is now the test in Anchor and Chubb. The matter then went on appeal to the Court of Appeal, and the Court of Appeal decision, while rather lengthy and dealt with quite a number of issues, actually could have been decided, could have been written much shorter, because what the Court of Appeal ultimately decided was that the natural reading of arbitration in Shanghai meant that Shanghai was a seat selected by the parties, and therefore Singapore was not the seat, and therefore the Singapore court was not competent to decide jurisdiction, and therefore the appeal was allowed, but on those grounds. So that's the history of the procedural history of BNA and BNB, and when the case was decided by the Court of Appeal, most commentators said that, well, this is an example of the court showing that the court will not bend over backwards in a tortured yoga pose to try and save an arbitration agreement. If indeed the arbitration agreement is not valid, then it would be left as that. An interesting coda to this is actually then the case went before, was taken into the Shanghai court. And the claimant in that case actually applied for determination as to whether the arbitration agreement is valid. And surprisingly, the Shanghai court found that it was valid, and it was possible for the SIC to administer an arbitration in Shanghai. Now, that's a topic for a whole nother discussion. I won't go into that. But I said I would touch very briefly on the treatment of the validation principle, since that featured quite strongly in this case. The tribunal had applied the validation principle to come to the conclusion that Singapore was the seat in Singapore law, and under Singapore law, the arbitration agreement is valid. The High Court in the Bna and BNB rejected the validation principle, expressly rejected the validation principle, saying that it was impermissibly instrumental, it was inconsistent with the party's intentions, it was unnecessary because Singapore endorsed the Latin maxim, which I will shorten as ut res magis. Basically, words are to be understood in a manner that the subject matter be preserved rather than destroyed. And further, that the validation principle could create problems at the enforcement stage because of Article 5.1a of the New York Convention. I thought that decision...
Stephen, if I could ask you to please wrap up. Thank you.
I will wrap up very quickly. I just thought that that decision really didn't understand how the validation principle operated. And the Court of Appeal didn't say anything about that, even though they mentioned the High Court's decision, because, as I said, the Court of Appeal said we don't really have to decide anything in this case because Singapore's not the seat. The point I wanted to draw was that this was dealt with by Anchor and Chubb in the Supreme Court. And the Supreme Court found that there was a validation principle, referring also to the ut res magis principle, but also recognizing that this was consistent with a validation principle that could be found in the New York Convention. And the Supreme Court's decision in Anchor and Chubb, I would echo what David said, is well worth reading because it also shows a very thorough understanding of the scheme of the New York Convention and other international instruments, and how English common law, and to this I would include Singapore and other jurisdictions following English common law, should be consistent with the New York Convention and the international system of arbitration. And that concludes my comments. Thank you very much, Swee.
Thank you, Stephen. So moving on swiftly to our third speaker, and we have a young lady from Malaysia, and her name is Charlaine Chin. She is a young partner at the Malaysian law firm of Roger, Darryl and Low. Charlaine, over to you.
Thank you very much, Swee. Can you hear me clearly? Very good morning or evening, depending on where you are. Well, today I will be speaking about the legal protection that is afforded to the public healthcare practitioners under the Malaysia Emergency Ordinance. Now, this piece of legislation came into force on the 11th of January this year, and it was following the proclamation of an emergency in the country by our king in the nation's effort to curb the COVID-19 pandemic. Now, over the past year, I think we all know the effects of the pandemic has really stretched our frontliners thin, and we've seen our resources dwindling. And I think it is against this backdrop that there have been recent calls for immunity to be granted to healthcare practitioners against medical or clinical malpractice suits. Now, let's talk a little bit about arguments for and against immunity. Now, those who are in favor of an immunity argue that there is an urgent need to alleviate the fear of being sued that's very real actually among doctors. And this is over and above the strain that they already are currently under. Another point that proponents of an immunity raise is that immunity would prevent doctors from being judged against an unrealistic standard of care, right? As we currently see now, there's so many doctors, nurses, healthcare workers who are being deployed to treat patients outside of their specialties. So that's also an area of concern. Now, on the other hand, those who are not in favor of an immunity argue that the current legal test is sufficient. It caters for emergencies. And because of that, an immunity is no longer necessary. I think the applicable test in the UK is the Wilmott test. It is the same standard that's applicable in Malaysia and several other Commonwealth jurisdictions such as Australia and Singapore. In addition to that, there's also arguments by those who are not in favor of immunity. And the argument that's raised is this: immunity would effectively deprive individuals from seeking proper recourse. So what we've done in Malaysia is this. Now, Section 10 of the Emergency Ordinance provides protection against legal proceedings for the public sector, but the acts or omissions that are covered have to be carried out in good faith. So you see, it's not a blanket immunity, it's qualified protection. And I think ultimately, it remains to be seen, of course, there aren't any cases currently pending on this piece of legislation. But I think the extent of the protection that's afforded under this legislation would hinge majorly on the definition that's accorded to the term good faith. So if we were to take a lenient approach, it can be argued that as long as a doctor exercises ordinary prudence, or as long as he or she acts with honest intent, then they ought to be covered by the protection. But I think some of the issues that may arise if that approach is taken is, number one, would that be taken to dilute the accountability of healthcare practitioners? And secondly, is such a lenient standard the appropriate test, especially when we're talking about one of life's most precious commodities, and that's our health? On the other end of the spectrum, if we were to take a more stringent approach, perhaps, there are authorities to suggest that the good faith defense is not applicable in cases where negligence is pleaded. So if there's no immunity, then the court will then have to revert to the common law test. So effectively, we're back to square one. And if that's the case, then one cannot help but wonder what the purpose is of affording immunity or protection in the first place if, when push comes to shove, the good faith defense is not going to hold up in the court of law. So I think it's against these circumstances that we see very few countries are slow to enact laws which provide protection for healthcare workers, and understandably so, I think. Apart from Malaysia, I think there's several states in the US, New York, New Jersey, Illinois, to name a few, that afford some sort of immunity to healthcare practitioners. And perhaps I think the solution may be in finding that rather delicate equilibrium between protecting our frontliners as well as ensuring that individuals who are harmed are not prevented from seeking redress. And on a concluding note, if I may be so bold as perhaps to suggest that Malaysia, I think, in my view, has taken a step in the right direction, and that is to provide protection, but it's a qualified protection and one that's centered on good faith. That would be all from me. Thank you very much. Over to you, Swee.
Thank you very much, Charlaine, and thank you for keeping to time. So there have been some questions as to where is the case that you're going to be talking about. And I did say at the beginning that we will be having 7 cases and 1 piece of legislation. And this is the 1 piece of legislation which, although it's not a case, we decided to include it because we thought that it was extremely topical. And although it is a Malaysian piece of legislation, nevertheless, these are issues that are vexing everybody across the world. So thank you for that, Charlaine. Can I now invite Vishal Kumar, who is a partner at the law firm of James Monteiro. And this is a boutique law firm that primarily focuses on areas of construction and commercial development. So Vishal is a partner there, and over to you then, Vishal.
Thank you, Swee. Good morning, good afternoon, or good evening, depending on where you're listening from. I will be talking to you about the Malaysian Federal Court decision in PJD Regency Private Limited and the Tribunal for Home Buyers Claims and another, which was heard with 2 other appeals. All these appeals involve disputes between housing developers and home buyers. For those of you familiar with KL or any of the other big cities in Malaysia, you will know that residential accommodation pop up like mushrooms after rain. If you're looking to buy a home in a brand new development, what usually happens is you would go to the developer showroom, they will explain the development, unit sizes, the usual. And if you're interested in buying, the developer will require a booking fee or a deposit. They call it all sorts of names, but what is essentially required of you is an initial payment to confirm your interest to purchase. This is something extremely common. Booking fees are collected weeks, if not months in advance of the actual signing of the sale and purchase agreement. Now, the odd thing about this is collection of booking fees is illegal. The sale and purchase of housing developments in Malaysia is regulated by statute, namely the Housing Development Act and the Housing Development Regulations. The full name of the act is the Housing Development Control and Licensing Act 1966. The Housing Development Regulations contain schedules which set out the required contractual terms between the parties. Our courts call these scheduled contracts. There are different schedules for different types of property. For example, the developer has 24 months to hand over landed properties and 36 months to deliver accommodation in a subdivided building, condominiums, for example. What these schedule contracts allow is for the collection of 10% of the purchase price upon execution of the sale and purchase agreement. Collection of booking fees is not allowed as expressly stated in the Housing Development Regulations. Despite this law expressly being in place for a few decades now, many unscrupulous developers still go ahead and impose booking fees, quite often as a precondition for sale. Now, if we go back to the federal court case, the common question of law that arose from all those appeals was this: where there is a delay in the delivery of vacant possession of residential property by a developer to the purchaser involving these scheduled contracts, when does the date for calculation of damages in favor of the purchaser begin? Is it from the date of the payment of the deposit or the booking fee, or from the date of the sale and purchase agreement? The developers who had, despite the law, gone ahead and collected this booking fee, of course, argued that time to deliver vacant possession should only start to run from the date of the sale and purchase agreement. If you recall, the SNP is signed much later. Well, our federal court was having none of it. The federal court considered the social legislative nature of the Housing Development Act, which was brought into force to correct the imbalance of power between developers and buyers. In fact, when the bill for this Housing Development Act was tabled in Parliament in 1966, the Minister for Local Government and Housing had this to say: legislative measures should be taken to protect the people from bogus or unscrupulous housing developers. Hence this bill. Considering developers were going ahead and collecting booking fees despite the express terms of the law, and all the elements to form a contract was achieved when the booking fee was paid, the federal court held that the 24 months or 36 months for delivery of vacant possession should run from the date the booking fee was collected. Developers are not allowed to circumvent the Housing Development Act and regulations by collecting booking fees in advance, but relying on the sale and purchase agreement for when the 24 months or 36 months starts to run. So instead of the usual buyer beware, in this case, it was a clear message: developers beware. If you're going to flout the law with this booking fee business, you are going to be held accountable from the date you collect that money. That's it from me. Thank you.
Thank you very much, Vishal. So we'll move on now back to our London office, and we will have we'll hear from Mr. Nicholas Higgs, a barrister with 39 Essex Chambers, London office. And over to you, Nick, with that difficult sounding case.
Thank you very much, Swee, and greetings everyone from a very cold and foggy morning in London. Let me transport you immediately to West Africa, the humid Niger Delta in particular, from which over 2 million barrels of oil are extracted every day. Much of that oil is transported across the Delta in a network of pipelines and various infrastructure. And those pipelines are run by a joint venture comprising a company called Shell Petroleum Development Company of Nigeria who have a 30% stake, and the Nigerian government, who have a 55% stake, amongst others. Unfortunately, these pipelines are known to have significant problems, including criminals extracting oil from them, bunkering, which they don't take much care over. And so the Niger Delta is also one of the most polluted places on Earth. The residents of the Delta are unsurprisingly unhappy about this. And that brings us back to London in October 2015. A group of over 40,000 residents of the Niger Delta launched an action in London against Royal Dutch Shell. Royal Dutch Shell are the parent company domiciled in London that's responsible for basically all of the Shell operations around the world, and are the parent company for SPDC. SPDC are domiciled in Nigeria. The appellants were arguing that Royal Dutch Shell owed them a duty of care in relation to the operation of this pipeline, which they said had been operated negligently, and that's why the damage had occurred in the Delta. Royal Dutch Shell said, well, sorry, this is not the right place to argue this. This should be being litigated in Nigeria, where SPDC are located. So the question for the court initially was a jurisdictional one. Can Royal Dutch Shell be sued in London for the claimed negligence of their subsidiary in Nigeria? The High Court considered that question and said no. The Supreme Court, sorry, the Court of Appeal also considered that question and similarly answered it negatively, saying, no, you can't bring this action here. They said it would be surprising if a parent company were to go to the trouble of establishing a network of overseas subsidiaries with their own management structure if it intended itself to assume responsibility for the operations of each of those subsidiaries. The Supreme Court earlier this year disagreed. They said there is a real issue to be tried here. They didn't find that there is negligence on the part of Royal Dutch Shell. They just allowed the applicants through this jurisdictional gateway. And the reasons they gave were primarily that Shell operates on quite a vertical management structure. So although the subsidiary has fiscal autonomy and it operates independently, a lot of the policies and procedures came down from the top, from Royal Dutch Shell in The Hague, actually, but ostensibly London. And this was all the health and safety requirements, the operational requirements, and everything that the subsidiary ought to have been doing to make sure that the pipeline was being operated properly. And so the Supreme Court said, well, although there is this fiscal autonomy and although these are separate companies, actually, there is a significant alignment managerially through the Shell operation. And therefore it is appropriate to ask in the English courts whether Royal Dutch Shell does owe a duty of care to the residents of the Niger Delta. The wider question is, so what? Does this matter? Well, for mineral extraction companies headquartered in London with operations around the world, this is quite significant. They will always have procedures and policies where they seek to ensure that their operations on the ground are carried out properly, and no doubt will be auditing to make sure that those are adhered to. They will be worried by this judgment. Similarly, if an approach is taken in other common law jurisdictions that have a similar test to jurisdiction, and that is whether there is a real issue to be tried, following the reasoning here, other multinationals headquartered in places such as Singapore or Australia or other common law jurisdictions may want to look through their policies and understand whether their corporate structure prevents them being sued in the domicile of their headquarters, or whether they do remain protected. There is a tension here because overall, we do want multinationals to be operating responsibly, and we would expect them to have these type of policies in place to control their subsidiaries. So we'll wait and see what the fallout of it is. The case is called Okpabi and Royal Dutch Shell and can be found on the Supreme Court website. Thank you, Swee. Back to you.
Thank you very much, Nick. So moving on swiftly to our next case from the peculiar year, we turn now to William Wong, who is partner of the Malaysian law firm Raja, Darryl & Low, and he will be taking us through a tax case. Thank you, William.
Thank you, William. Hello, everyone. Today I'll be talking about the case of Government of Malaysia against Noyana Nona Chua, I think. This case is about the recovery of unpaid taxes, actually. But before I start, perhaps what I will do is to briefly go through what typically happens in a tax dispute in Malaysia, just to give some context to this case. You see, in Malaysia, for taxpayers to dispute tax assessments, taxpayers can appeal to a specialist tribunal known as the Special Commissioners of Income Tax. However, once tax assessments are raised, the tax is due and payable within 30 days of the service of the notices of assessment. And the law says that this is regardless whether an appeal against the tax assessments is made. And this is known amongst us tax practitioners in Malaysia as the pay first, talk later provision. And to add to that, if you fail to pay the tax, the amount of unpaid tax will be increased by 10%, and the revenue may commence civil recovery proceedings to recover the unpaid taxes, very much like how banks would commence proceedings against defaulters. In tax recovery proceedings in Malaysia, the government would typically apply to enter summary judgment, and the principle is this, and I believe the same principle applies in most jurisdictions. The plaintiff may, on the basis that the defendant has no defense to a claim, apply to the court for summary judgment. And when it comes to tax recovery, the law, the income tax law specifically says the production of a certificate signed by the Director General, giving the name and address of the defendant and the amount of tax due shall be sufficient evidence of the amount due and sufficient authority for the court to give judgment for that amount. And there's one other provision in the law that says that in any tax recovery proceedings, the courts shall not entertain any plea that the amount of tax sought to be recovered is excessive, incorrectly assessed, under appeal, or incorrectly increased. Therefore, the power of the courts to look into a taxpayer's pleas are quite limited, actually, thus rendering tax recovery proceedings, some would say, almost indefensible. And therefore, the government succeeds in the vast majority of tax recovery proceedings. And this is what this case is about, really. You see, what happened here was when our former Prime Minister lost the elections, Revenue started looking into his and his family's tax affairs. And the Revenue claimed that he and his children owe a not insignificant amount in income tax arrears. And in all but this case, the Revenue managed to obtain summary judgments against the Prime Minister and his family. And in this case, the Revenue alleged that, in this case, it involved the daughter of the former Prime Minister, and then the allegation was that the daughter of a former Prime Minister did not pay the tax owed. And the law says you have to pay first, remember, at least the law in Malaysia. And the Revenue then proceeded to file a writ of summons and statement of claim and applied to enter summary judgment, run-of-the-mill stuff in tax recovery proceedings in Malaysia, really. But one peculiarity in this case was that the affidavit in support of the application did not state that the defendant had no defense to the claim. Instead, it stated that the defendant had no defense with merits. And remember, a summary judgment application must be premised on the ground that the defendant has no defense. So the court decided that what the Revenue really meant was that the defendant actually had a defense, but the defense was without merits. And the other point was that the court also found that there was no evidence that the person who signed the certificate as proof of the amount of tax due and payable was an officer appointed to exercise any function of the Director General. Therefore, the court said that there was no sufficient authority to give judgment on the tax due and payable and remitted the case back for trial. Now, this case does not change the position when it comes to tax recovery proceedings or summary judgment. The test principles are still the same. But I think why this case is important is that it reminds us that the court's power to enter summary judgment is an exceptional power. This is more so when it comes to tax, which is penal in nature. Therefore, the courts should always bear in mind the possibility of arbitrary or incorrect assessments. And I think this is what the court did here, bearing in mind the possibility of arbitrary assessments. That is all from me. Thank you all.
Thank you very much, William, for that tax case. So still staying in Malaysia, we turn now to Nadesh Ganabaskaran from the Malaysian law firm of Malek, Paulian and Gan, who will touch on the case of Master Mulia and Siegel Rose. Over to you, Nadesh.
Thank you, Swee. Good evening to those in Malaysia and good morning to those in UK. I'm Nadesh Ganabaskaran, and the case that I'm going to be dealing with today is called the case of Master Mulia and Siegel Rose. It is a federal court case which dealt with the issues of setting aside an arbitration award under Section 37 of the Malaysian Arbitration Act. For those who are familiar with Section 37, it is the provision in respect of setting aside an award being in breach of the rules of natural justice and other relevant provisions. The equivalent provision in the UK statute would be Section 68, subsection 2, subsection 1 of the UK Arbitration Act concerning the tribunal's failure to afford the party a reasonable opportunity to act fairly and impartially in the matters of the arbitration. The reason why this is an interesting case is because generally Malaysian judiciary has been pro-arbitration in ensuring the promotion of Malaysia as an arbitration-friendly country. However, here, the Federal Court of Malaysia, being the highest court, had affirmed the decision of the Court of Appeal in setting aside the arbitration award in totality. So that then raises the concern whether are we still an arbitral-friendly country or otherwise. I'll be looking into these issues and providing a conclusion on it. Before that, the brief facts are this. Siegel Rose had chartered a vessel from Master Mulia capable of carrying out undersea pipeline installation works. During the voyage, there was a damage to one of the pipeline installation arm, which was known as the stringer hitch, which caused delays to the delivery of the vessel back to Master Mulia. And in turn of events, Master Mulia commenced in arbitration proceedings against Siegel Rose, claiming for damages of delay and rectification costs. The arbitrator found in favor of Master Mulia and awarded the damages. However, in coming into making his award, the arbitrator had relied on two extraneous evidence which were material to the cause of damage and had not provided the parties the opportunity to submit on this extraneous evidence or to rebut or rely on an expert report on it. So when the matter was then, Siegel Rose being unhappy had then referred the matter to the High Court to set aside the arbitration award under Section 37 for one of the provision of it being in breach of the rules of natural justice. At first instance, the High Court judge found that the arbitrator had indeed breached the rules of natural justice arising from his reliance of the two extraneous evidence without first affording parties opportunity to be heard on the issue. However, the learned High Court judge did not set aside the award on the basis that he had imported a test which is common in the Singapore Arbitration Act, which is was there a real and actual prejudice suffered by Siegel Rose as a result of that breach. So in reliance of two Singapore cases, the arbitrator, the learned High Court judge said that since Siegel Rose had failed to establish prejudice, therefore he was not going to set aside the award. It should be borne in mind that in Singapore Arbitration Act, the element of prejudice is expressly stipulated. However, in our Malaysian Arbitration Act, the element of prejudice is not stipulated expressly. It's just that the award being in breach of the rules of natural justice. In turn, the Court of Appeal, having heard the appeal, had set aside the award in totality on the grounds that a breach of natural justice would entail the entire award being set aside. The Court of Appeal judge found that the piece of two extraneous evidence was so material that had it been considered by the parties, it could have changed the turn of events in making of the award. The matter was then referred to the federal court, and the question of law that was posed was whether in our Malaysian law, prejudice is an element to be considered in setting aside an award under the Section 37. Our courts answered the question and held that the question of whether an award ought to be set aside for breach of rules of natural justice is not dependent, nor does it turn on the principle, does it turn on the issue of prejudice arising from the said breach. What is more important is, while prejudice, though a relevant consideration, is not a requirement under our Malaysian Act. The federal court had ruled that the courts must be mindful of importing principles of foreign jurisdiction without careful consideration of foreign law in question in respect of our Malaysian Arbitration Act. While foreign judgments, particularly the interpretation of statutes, are persuasive here, provided they are in pari materia or substantially similar with our provision of the law. In conclusion, I would like to say that the court's discretion in setting aside an arbitral award under Section 37 is unfettered. However, the court is not bound to set aside an award merely because the grounds where the challenge is based have been met. The court may still take into consideration the objective and the policies of underpinning the Arbitration Act of Malaysia in making the ultimate decision. Our Malaysian judiciary is generally pro-arbitration since it is the mode of dispute resolution specifically chosen by the parties. It's presumed that the parties desire finality rather than legality by choosing arbitration. Thus, arbitral awards are often upheld unless there is a serious irregularity in them or in the manner they were made. Final conclusion is that there has been no change in Malaysia's judicial position on the importance of arbitration, recognition of very limited curial intervention by the courts. This case is a peculiar case decided surrounding the learned arbitrator's conduct in relying on extraneous evidence, and therefore shall not be interpreted as a general position of the Malaysian judiciary's stance of setting aside arbitral awards. That's about it, and thank you, Swee.
Thank you very much, Nadesh. So rounding out at number 8, leaving the best for the last, is Richard Wilmot-Smith, QC. Over to you, Richard.
Hello. Right. Imagine you are an employer under a construction contract. You enter a dispute with your main contractor, and in doing so, you have an arbitration clause which provides for 3 arbitrators, and you nominate Mr. Rokerson, we'll call him, as your arbitrator. Sorry, as you are the employer, but imagine the contractor nominates Mr. Rokerson as their party nominated arbitrator, and the employer nominates somebody else. The contractor then has a dispute with the employer arising out of exactly the same facts which relate to the dispute which the main contractor has with the employer. So it's a straightforward dispute up the line. The employer then nominates Mr. Rokerson as its party nominated arbitrator, and the subcontractor nominates their own arbitrator. Now, imagine you are Mr. Rokerson. You have been nominated by the same party in respect of effectively similar disputes up the line and down the line. What should you do? Should you disclose the existence of your appointment, or should you not disclose the existence of your appointment? A few years ago, the answer would have been no, you wouldn't have to do that. That being a party nominated arbitrator, there is confidentiality between you and the parties to that arbitrator you're nominated on, and that applies to both. However, times have changed, and this type of problem has been discussed quite a lot. Basically, if you are an arbitrator in the situation of Mr. Rokerson, whose example I've given, you should disclose. Now, it's taken a long time for this finally to be declared the law. And it's been declared the law in the case of Halliburton against Chubb. We had Chubb in the first talk, where Halliburton were complaining about non-disclosure by Mr. Rokerson, who is one of the most distinguished arbitrators, and he failed to make a disclosure in similar circumstances. This was a string arbitration about the Deepwater Horizon with insurance, an insurance dispute. And he did not make disclosure when he should have done. Now, the problem for Mr. Rokerson was his anonymity, or the anonymity of the parties. And quite a lot of the time, while the case was going up through the courts, he was Mr. R. But the Supreme Court outed him as the quote, I'll put it in inverted commas, offending, unquote, arbitrator. This was heard by the Supreme Court in England in November 2019, and it troubled them a lot. And it wasn't until November 2020 that the Supreme Court gave its judgment. And it was, the leading judgment was by Master Patrick Hodge, Lord Hodge, and it is a masterwork of analysis of duties of arbitrators, but it goes further. It's an analysis of duties of tribunals to make disclosure and the duty of, to make disclosure. I can see that we're running out of time. Swee's raised her hand. Now, basically, it is now the locus classicus for describing or considering bias and apparent bias. It's going to have worldwide reach. It's 50 pages long. It's well worth reading because it's very smooth in its approach and very clear in its approach. So that's Halliburton, Swee. Truncated, I'm sorry.
Thank you very much, Richard. So that rounds up our 7 cases and 1 piece of legislation that is interesting, that's topical. And to give us a roundup of today's learning is Justice Lim Chong Fong, who is the Kuala Lumpur High Court Construction Judge. Over to you, Judge.
Right, thank you, Swee. Greetings from Kuala Lumpur, Malaysia. The topic today is interesting cases from a peculiar year. And I'm sure you all agree that we certainly have had a very interesting evening listening to all the speakers. There were 8 presentations on a wide spectrum of diverse topical subjects in 2020, covering the United Kingdom, Singapore, and Malaysia. In the remaining webinar time left, I've been assigned to round up the cases presented succinctly with my short takeaway remarks. The first case presented by Mr. Thomas is the UK Apex Supreme Court case of Anchor versus Chubb, which dealt with the choice of law pertaining to an arbitration agreement. The court affirmed the validation principle in determining the law of the arbitration agreement. In this respect, the courts, by this validation principle, should lean towards interpreting the agreement to be valid instead of void or unenforceable, as I understand it. The court sought to discover the implied choice of the arbitration agreement. It was therefore held that the law of the seat need not necessarily be the default law of the arbitration agreement, if that results in avoiding the arbitration agreement. So in conclusion, the application of the validation principle can, in my view, be seen as a pro-arbitration policy of the court. Moving on, the second Singapore Apex Court of Appeal case of Bna versus BNB and another, presented by Mr. Lim, also dealt with the law of the arbitration agreement. However, in contrast with the UK Anchor versus Chubb case, held that the default law of the seat is the law of the arbitration agreement, notwithstanding that it would result in the arbitration agreement to be held to be invalid. It can be concluded that the aforementioned validation principle was not applied in this case. However, these cases can, in my view, be reconciled from their differing facts, particularly the provisions in the contract, as well as the arbitration agreement. In this Bna case, unlike the anchor case, the law of the contract, as well as the place of the arbitration, were specified. The third presentation by Ms. Charlaine is on Section 10 of the Emergency Essential Powers Ordinance 2021, made pursuant to the health emergency proclaimed in Malaysia on 13th of January this year. It deals with the legal immunity of healthcare professionals in medical negligence lawsuits taken against them. This is a recent piece of legislation with no court cases as yet. In my view, this provision is welcome in view of the circumstances these healthcare professionals are currently working in tirelessly and often over time. The foreseeable challenge for the court, in my view, is interpreting the width of the immunity, particularly the qualified protection of proof of good faith exercised by the professional. The fourth Malaysian Apex Federal Court case of PJD Regency versus Tribunal Tuntutan Pembeli Rumah, presented by Mr. Vishal, is a recent landmark case on interpretation of a statutory standard sale and purchase agreement pervasively used in housing development projects in Malaysia. The court held basically that the effective date of the agreement is the date the purchaser paid the booking fee prior to the date of execution of the contract, notwithstanding that it has been expressly stated as such in the agreement itself. The effective date is relevant for purposes of calculation of late completion damages. The court held that the Housing Development Control and Licensing Act is a piece of social legislation that safeguards the purchaser. This, in my view, is sensible on policy consideration because the purchasers do not enjoy equal economic bargaining power vis-a-vis the housing developer. The fifth UK Apex Supreme Court case of Okpabi versus Royal Dutch Shell, presented by Mr. Higgs, touches on environmental damage and human rights abuses claim against the tortfeasor as well as its parent company due to pipeline oil spills and pollution in a foreign country. The court found, and unprecedentedly, that the parent lawsuit in the UK should proceed to trial because the parent company owed an imputed duty of care by reason of the degree of control and de facto management of its subsidiary. This, in my view, is a bold and strict approach that rejected corporate separation to limit risks associated with operation of its foreign subsidiary company. Moving on, the sixth Malaysian High Court of First Instance case of Kerajaan Malaysia versus Noriana Najwa Najib, presented by Mr. Wong, on summary judgment application in respect of recovery of unpaid income tax, is a rare occurrence where summary judgment was denied. Although such applications are normally open and shut cases, this case highlights the importance of getting the cost papers right. The affidavit of the Inland Revenue Board was defective in respect of the averment code had no defense on merits, instead of the prescribed code had no defense, contrary to Order 14, Rule 2 of the Rules of Court. In addition, and more importantly, the certificate of proof of tax due wasn't signed by the Director General of Inland Revenue Board, and this is fatal. So in the circumstances, the Inland Revenue Board has to therefore prove its tax recovery in a trial. The seventh Malaysian Apex Federal Court case of Master Mulia versus Siger, presented by Mr. Nadesh, is another landmark Malaysian Apex Court case which concerns the setting aside of an arbitral award pursuant to Section 37 of the Arbitration Act 2005, based on denial of natural justice. The arbitrator in that case applied his own special knowledge on causation of the fact in issue based on extraneous evidence without affording the parties the opportunity to comment on it. Although no actual or real prejudice was occasioned by denial, as found by the Court of First Instance, the Appellate Court found that this is immaterial because there isn't such additional requirement expressed in Section 37 of the statute. In other words, denial of natural justice simpliciter suffices in this case. This is, in my view, a rare occurrence based on the special circumstances of the case. Finally, as to the 8th UK Apex Supreme Court case of Halliburton Energy versus Chubb Bermuda Insurance, presented by Master Wilmot-Smith, concerned the removal of an arbitrator who, without disclosure, accepted multiple appointments concerning the same and overlapping subject matter with a common party. It is interesting to note that the court did not remove the arbitrator for non-disclosure of his aforementioned involvements or conduct giving rise to justifying doubts as to his impartiality. It was held that there is no difference between the tests laid down in Section 24, subsection 1, subsection A of the Arbitration Act 1996 and the common law test of real possibility of bias. Nonetheless, the court was mindful of the differences in both the nature and circumstances between judicial determination of disputes versus making of arbitral awards when I read the case. I surmise that the resolution of this problem is fact sensitive, depending on the exact circumstances of each case, but with perhaps some laxity accorded to arbitrators over judges. In conclusion, I have found this webinar very enlightening and beneficial. There has been superb sharing of knowledge, and I look forward to many more webinars ahead on a regular basis to stay updated and be abreast on the current development of the law. So thank you, and back to you, Swee.
Thank you very much, Judge. It has been a very dense hour, I think. And so in order to give our brains a rest, I think that may I invite Justice, Federal Court Justice Dato Nalini Padmanathan to bring this event to a close. Judge.
Thank you very much, Swee. I won't be talking about the law at all. It is certainly a privilege to make the closing remarks. First, on behalf of the alumni, Malaysian Middle Temple alumni, I express my sincere gratitude and appreciation to the organizers, 39 Essex Chambers, for proposing the webinar and hosting it. We're very, very grateful also and appreciative of the considerable efforts made by the speakers. I mean, you were definitely the stars tonight. And the moderator, Swee, wonderful, and Chong Fong, the excellent summarization of all the case law. Most of all, perhaps, our thanks goes to all the participants who made this webinar meaningful. The breakdown of the registrations by location was astonishing, ranging from, perhaps not everyone attended, but it was amazing the number of registrations, ranging from London, 115, the rest of the UK, 51, Sabah, 123, Kuala Lumpur, 86, Sarawak, 11, Singapore, 20, Hong Kong, 7, going on to Amman, Moldova, Mexico, Dubai, Dublin, Kampala, Cologne, Lahore, Phnom Penh, Seoul, Tokyo.
Ladies and gentlemen, we appear to have lost a judge there. So indeed, there has been a very, very, Judge, you're back with us.
Oh, sorry, did you not hear me?
No.
Can you hear me now?
Yes,
can you hear me now?
Yes,
right. I was just saying the discourse today showcased diversity and plurality on a number of levels. Firstly, the audience comprised participants from various jurisdictions, and our speakers from both jurisdictions touched on a diverse range of legal topics and issues in the UK and Malaysia. The speakers also represented diversity in terms of their range of experience, as we heard from extremely skilled QCs, as well as extremely bright young advocates. In the space of an hour and perhaps and a quarter, we sought to encapsulate and present some aspects of Malaysian and UK law, as well as afford our younger members the opportunity to demonstrate their advocacy skills before an international audience, as Tan Sri Cecil said. I hope we succeeded. It is part of the alumni's focus this year to promote and give a voice to the younger advocates. In conclusion, I emphasize two things. Firstly, the future of the law is digital. Secondly, we need diversity of thought to become more innovative as we face new challenges in the law on a global scale. And that can only come from greater interaction in fora such as this. I hope this is the first of many such interactions, perhaps the next time with greater audience participation. Thank you very much indeed. Good evening. Thanks, Swee. Back to you.
Thank you very much, Judge. To everybody who stayed with us throughout this hour, thank you very much. It's like I said, it's been a very, very dense hour. We've not allowed time for Q&A, but as promised, everybody who is registered will get an email following this, and you will get a list of all the cases and all the citations. And with that, you can, if you have any burning questions, do reach out to the speakers. To all the speakers, thank you very much for your presentations, and to everybody, good evening, good afternoon, good morning. We'll be seeing you soon. Join us again, please.